I'd like to give you a synopsis of dangerous driving in the Criminal Code in Ontario. Section 320.13, sub 1 of the Canadian Criminal Code outlines the offense of dangerous driving. More specifically, that type of driving would include something like this. If you're driving in a manner that puts yourself in danger or the public in danger, you could be charged with this particular offense. If you're charged with that particular offense, the Crown is going to look at the facts of the case. They're going to look specifically at that driving, and they're going to make an election to proceed summarily or by indictment. If the Crown, and it's typical in these cases where the Crown is going to proceed summarily, and when it's proceeded summarily, it can be considered less serious. The penalties for these types of offenses are set by the judge upon conviction or upon the guilty plea. There is a possibility of a period of incarceration. There is distinctly a possibility of a license suspension. That's quite common. And in addition to that, it would be called a driving prohibition, which is different than a suspension in the traditional sense. And a driving prohibition is something that's ordered by the judge who's simply listened to the facts. The Crown has certain things to prove in a case like that. And those fundamentals, those absolute musts, would include things like the identity of the person driving. It also need to prove, beyond any doubt, the date, time, and the jurisdiction of where this may have occurred. The Crown would have the responsibility of demonstrating that the public was in fact in danger. They would also have the responsibility of proving to the court that the defendant was driving in such a fashion that it ought to be considered dangerous. And when that happens, that would import the conviction and all the subsequent penalties for that offense.